All right, let's dive in. Today we're looking at a really key part of the criminal justice process.
Yeah, specifically Rule 116 from the Philippine Revised Rules of Criminal Procedure.
That's the one covering arraignment and plea. We've got some source material on it.
Exactly. Think of it as like the formal kickoff in court. It's where the accused hears the charges face to face with the judge and says how they respond.
And our goal here is to really unpack Rule 116. What's its purpose, what protections are built in.
And how it shapes everything that comes after for everyone involved, the accused, the prosecution, the whole system.
Because it sounds like more than just ticking boxes.
Oh, absolutely. It's fundamental. It's about fairness, due process, right from the get-go, sets the stage.
Okay, so let's get specific. Rule 116, arraignment. Someone's accused, they're in court. What actually happens?
So the arraignment itself is the formal reading of the official charge, the information or complaint. It's read to the accused in open court.
And then they're asked how they plead.
Correct. Guilty or not guilty.
Why is that reading aloud so important? Could they just, read the paperwork?
It's about due process. The accused has the right to be specifically informed formally about what they're actually facing.
So they can understand it and start preparing?
Precisely. It also formally gives the court jurisdiction over them, and for it to be valid, a few things must happen.
Okay, what are the essentials?
The accused has to be there physically. They need a lawyer if they don't have one. The court must appoint one, a counsel de officio.
Right.
The charge has to be read in a language they actually understand. That's crucial.
Makes sense.
And finally, they have to enter that plea.
Presence, lawyer, understanding, plea. Got it. What if something goes wrong there, if one of those isn't met?
Big consequences. If the arraignment isn't valid, the trial basically can't proceed legally.
Wow.
Any judgment later could be declared void. It undermines the whole process because that foundational due process step was flawed.
Okay, so very high stakes. Now, the plea itself, you mentioned guilty or not guilty.
Those are the main ones. Guilty is admitting the facts alleged. Not guilty is a denial, which means you're heading to trial.
What happens if someone pleads guilty? Especially a serious case. Does the court just accept it?
No, not at all. The court has a really important duty here. It must conduct a searching inquiry.
A searching inquiry. What does that involve? What's the judge looking for?
The judge needs to be absolutely sure about a few things. Is the plea voluntary? Is the accused mentally okay, capable of understanding? Do they fully grasp the rights they're giving up, like the right to remain silent, confront witnesses, present evidence? It's huge.
Yeah, those are core trial rights.
Exactly. And do they understand the possible consequences, the maximum penalty they could face?
So it's a deep check on understanding and voluntariness.
Yes, to prevent what's called an improvident plea, one made without really getting it, or under pressure. The court can even hear evidence just to be sure.
Can someone take back a guilty plea later if they realize it was, improvident?
It's possible, yes. If they can show the court it wasn't properly made, not fully informed or voluntary, it's not easy, but the option exists.
Okay. Now, Rule 116 also talks about pleading guilty to a lesser offense.
Yeah.
That's plea bargaining, right? Section 2.
That's it, exactly. Plea bargaining. The accused offers to plead guilty, but to a less serious crime that's necessarily included in the original charge.
Like pleading to homicide if the original charge was murder.
Perfect example. The elements of homicide are all within the elements of murder.
Who needs to agree for this to happen? Is it just up to the accused and their lawyer?
No, this is critical. It needs the consent of the prosecutor and the offended party, the victim or their representative.
Both.
Both. But even if they both agree, the court still has the final word.
So the judge isn't bound by their agreement.
Correct. The judge has discretion. They have to look at the facts, see if the lesser plea is justified, if it serves the interests of justice overall. It's not something the accused can demand.
Understood. So if the judge does approve the plea to the lesser offense, what happens then?
The accused is convicted of that lesser crime, gets the penalty for that crime.
Yeah.
Crucially, they can't be tried again for the original, more serious charge.
Double jeopardy protection.
Exactly. Civil liability might also get sorted out, often involves restitution. And, from the system's point of view, it's a major tool for efficiency, helps manage the caseload.
This sounds connected to that Estepona v. Labrigo case you mentioned. How did that change things?
Hugely significant case. The Supreme Court basically said you can't have an absolute ban on plea bargaining, specifically referencing drug cases where it had been prohibited by law.
Oh, okay.
It affirmed plea bargaining as more than just convenience. It's linked to the accused's procedural rights under the court's rulemaking power. Shows how these rules get shaped by court decisions.
Definitely shows the law evolving.
Oh.
Are there times when the arraignment itself might be put on hold, suspended?
Yes, Rule 116, Section 11 covers that suspension.
On what grounds?
Key grounds are if the accused seems mentally unfit to understand the proceedings or make a plea, or if there's a challenge pending, like a petition for review of the prosecutor's decision filed with the Secretary of Justice.
So pausing things to ensure fairness, basically.
Precisely. If the accused can't understand, or if the very basis of the charge is under review, it makes sense to pause. It's a balance, though, with the right to a speedy trial.
Right, always that tension. So wrapping this up, what are the core takeaways for us about Rule 116?
Well, it's that vital first formal step where the accused is informed and responds. It sets the whole direction. The safeguards, like that searching inquiry, are there to protect fundamental rights.
And plea bargaining is a key mechanism.
A key mechanism, yeah, for efficiency, but needs consent and judicial approval. And for you listening, remember, the lawyer's role is critical here for the accused.
Absolutely.
And often, especially with a private victim, sorting out the criminal plea is tied up with resolving the civil damages side of things, too.
So it's clear Rule 116 isn't just procedure, it's this intersection of rights, oversight, efficiency, and negotiation almost.
It really is where all those things meet early in the process.
Which leaves us with a final thought. How does a rule like this, constantly being interpreted by courts, maybe even challenged, like in Estepona, show us the justice system's ongoing struggle, that struggle to balance the right to a full, complete defense against the practical need to resolve cases justly, but also, efficiently? It's a tightrope walk.